and now we move on to the next topic, gaining IP experience, get the loot, and unlock new levels. One of the most common questions I get from video game developer friends, which of course I'm not providing legal advice, I'm working in an international organization, but one of the questions which I always am asked is, so how do I patent my video game? So the idea in this panel is going to be trying to present some of the basic issues related to intellectual property. So what's the difference between a patent, what's a copyright, and what is a trademark? And for this, I'm really happy that we are joined by these really excellent experts, so from Serbia and from London coming as well. Gaetano, please, if I can ask you to join us, have your presentation, and yes, wherever you wish, you can walk around. There's cameras that will follow you anyhow.
Oh, let's make it
simple. And then just to add that we'll also have a chance to listen to a presentation from Goran from here in Serbia, from Karanović&Partners, and from Zorica Gulas from the IP office. And it's a pleasure to have you all in this panel. Gaetano is one of the main experts on all issues related to IP and video games, but not only IP, but in general, all the issues related
za intelektualnu svojinu I video igre.
And just to add that Gaetano is also one of the
Gaetano
of this major
je također
mastering the game. It's 400 pages.
jedan od stručnjaka
on video games. It is, in a way, a Bible of all these issues, and it's very, very useful for lawyers and in-house counsels. But of course, there are certain chapters there especially relevant to video game developers, and I'm handing over the floor to you, Gaetano. Please.
No, and if I can do a little bit of self-promotion, it's amazing as a law book is for free to download. There's one of the rarity of text in the field. So thank you very much, WIPO, for actually publishing it. Thank you. So I have an incredible task. I mean, we're running out of time. I have 30 minutes and I have to talk about video games and intellectual property law. And I spent the last 15 years of my life doing that. So it's going to be a compressed presentation. And I'm really conscious of what is just been mentioned. The point is, developers, they don't have the time, they don't have the full understanding of the reason why it's important. And of course, they speak a different language. That is the main difficulty. We lawyer, and sorry, I'm an academic, but even if I don't look like I'm an IP lawyer, and it's the issue of language and to transfer this knowledge, because IP is something that is fundamental for the industry. I mean, there wouldn't be an industry, a video game industry without IP. You wouldn't successfully commercialize, sell, and make money out of your games if it wasn't for IP. But IP is a complex area of the law. It's complex for a reason. I'll get back to that. And doesn't fully fit with video games. I mean, even the way we define video games is different. I mean, a few years ago, we started moving from the concept of video games to a form of interactive entertainment because it's more embracing. And recently, I mean, recently for the people not in the industry, there's been a buzzword that is going around, and I promised Frederick to use the word at least 3 times in this presentation, the metaverse. There is something futuristic and very new for people outside of the video game industry, and it's what the video game industry has been more or less trying to do with their proto-metaverse virtual world online environment for a couple of decades. I don't know, I mean, I shouldn't say that we are recorded, but you remember Second Life. I mean, most of the video from Meta, they remind of a beta version of Second Life. I mean, the video game industry is going to be at the forefront of everything in just a few years, not only because of the increased gamification, but the way we communicate. If there is an industry that is good at doing something that is immersive and interactive, that is the video games industry. And this, I mean, the way I was been talking about the industry changed a lot in the last 10 years. I mean, I remember starting presentation trying to make the point on how important the video game industry is, how much money they make, what impact they have on society. I don't have to do that anymore. Now it is obvious, and probably even during the pandemic, we realized video games are great, video games are good. Video games, they give us a way not only to play and interact with creativity, but also to communicate. They're amazing. IP law, however, is very technical and is territorial. So sometimes there are some clashes. When you try to define a video game from an IP perspective, you realize that it's already a complex IP product, and now they're moving into services. That creates a difference. It is entangled in a very complex contractual matrix, and it also has to follow and obey, being a global business, a very complex regulatory framework. Because when you then commercialize the video game through your IP, you have to deal with all the local regulatory frameworks in all the countries in which you want to distribute the video game. And the industry is young, is fresh, is global, is born digital, is highly innovative, highly creative. This tends to clash with regulation. This tends to clash with law and international agreement, because they are slow to react. And most of the time, video games are the first industry to do something that spark a lot of interesting legal questions to which we don't have the answer. So we have to play around. We have to go back to the basic, go back to theory in order to understand what exactly is going on, how we identify and frame the problem in an IP way, and also trying to suggest a solution that wouldn't involve, massive court cases all over the globe. But also this mix of complex issue creates a difficult relationship. There are overlaps, there are gaps in interpretation, and sometimes there are mismatches when you look at intellectual property from international and comparative point of view. You might have jurisdiction that protect in a particular way that is opposite to what a judge in another country, country X, would deal with exactly the same problem. And another unique and important aspect of video games, and that they are so powerful, that they do have a transnational effect that cross barriers. So they are probably, together with social media, but I don't want to get there, one of the forms of entertainment that actually is capable of exporting community rules, exporting approaches to creativity, exporting approaches to regulation that go beyond the framework. If you set up in your online community in a video game a given set of rules, this set of rules are going to be followed and embraced by countries in multiple jurisdictions in which that regulation, that approach to that might be different. This afternoon, I hope we're going to get a little bit more in detail into that. But when you look at video games, of course, difficult to define from an IP perspective, there are multiple and very different forms of IP that, of course, are to some extent harmonized, not entirely harmonized, and as any lawyer would tell you, the devil is in the details. It's not on the general concept that is harmonized, but now these interact with the rest of the legal regime, with limitation and exception, with contract law, and so forward. And one of the most important, probably, aspect of this combination of IP, because they can all protect the video games, most of the time they all protect the video games, is their relationship with the creative use of third parties' intellectual property, and really, really important, the relationship with end user license agreement and term of services. And I always ask every audience, how many of you have ever read an end user license agreement of any sort? We are less than 3%. And I do it because it's my job. I mean, I would never do it for fun. And these are incredible governance instruments that some video game companies are using amazingly well to navigate the complexity of the relationship with the user. And also, one of the things you can notice, if you take a software company or a social media company end user license agreement, and you compare it with one of the modern video game end user license agreements, you will see that they are human-centric. They are translating very complex legal issue in language that is understood by the people signing it. Of course, no one is going to read it, and that's another problem. But at least the video game industry has been the first one that has made actually serious attempt to translate it for their players. Because you cannot expect anyone to read a 15 pages document in font 10 in order to understand what their rights are and what they can and what they cannot do with the video game. And starting with the list, I mean, I'm focusing mainly on copyright, patent, trademarks, and a note on design. The relationship between video and copyright is complicated. To use complicated for the fifth time, because copyright is not entirely designed for interactive creation, complex interactive creation. And copyright is the one that possibly, even if there is a substantial level of harmonization globally through the WIPO treaties, for instance, or regionally, the EU directives and the numerous decisions of the Court of Justice, still have a very, an understanding of copyright is really linked to the jurisdiction you are in. Copyright is really linked to the culture of every given society, the way we look at particular limitation or exception, the way we look at subject matter. And these approaches are so different that when you have to consider the copyright protection of some particular elements of a video games that are out of the box. Of course, the music, the text, the code, those are all protected by copyright. But when you start moving into the more interactive element and the soul, the character of a video game, the way you play the video game, the mechanics of the video games, copyright struggle internationally and find a common solution. And this question of legal natures also impact on concepts such as exhaustion, or concepts like the concept like interoperability, or I don't know if you're probably in this room, everyone heard the concept of cloning a video game. On top of that, there is a separate set of issues that are the one directly connected with interoperability and the interactivity with the user. There are normally approach using yes, copyright, but also technological protection measures and EULAs and TOS. Actually, they become of extremely importance. I'm not going to go through the list. There are a lot of issues. There has been a lot of discussion in the last few years about artificial intelligence. It's another aspect of relationship between new technology and IP in which the video game companies is largely experienced, because they've been using machine learning for decades, for the creation, for the experience, increasing the user experience, and also for creating video games. I mean, there is actually a Queen Mary project, it's games by Angelina. It was actually an algorithm that was creating game entirely independently. These are things that the industry has been playing around for almost a decade. So it's important to ask them what the problems are. Moving to the fundamental question, because I'm going to cherry pick the things that I think are more interesting to discuss. When you ask a copyright lawyer what is a video game in copyright terms, depending where they're from, they're going to give you a different answer. And in some countries, they have a really unitary approach because they're trying to make it fit in their list, in their history. So they're looking at them as audiovisual work, a computer program, something else, and I'm keeping it vague because a lot of cases in some countries, they date back to the 80s. And so judges had to deal with video game infringement cases when even software was a new thing for them. So some of the outcome might smile nowadays, but those were different time. Other countries have actually a distributive approach, and they try to look at the video games holistically with profound consequences. Actually, in 2013, WIPO commissioned a study on the legal nature of video games that is available online, and is already partially outdated because there's been extensive case law in order to determine. So a very simple question, what is a video game in copyright terms, gets different answer. This mainly because when you try to look at video games from a copyright point of view, you see that there are an extensive, this list is of course not exhaustive, that's just an example. There are hundreds, if not thousands, of different components that are already protectable by copyright independently, created by hundreds or thousands of different authors. So you have to take this into consideration and then look at the video game. Of course, there are consequences. I mean, you have to be sure that all this creativity in different parts of the world is actually challenged to a single entity in order then to commercialize, to publish and distribute the video game. So this sometimes very complex paperwork, because in some countries an employment agreement would be fine. In another one you have to have more specific terms and so forward, mainly based on jurisdiction. But we're talking most of the time for a AAA video games, thousands and thousands of people in multiple jurisdictions. And then you have to look at the video game. And in the UK, that I don't know if you're aware, recently left the European Union. In the UK, we have an old case from almost a decade ago in which the court had to actually figure out how to determine what has been taken, what has been infringed in this copyright case, and had to reconnect it to the closed list system. In the UK, there is a closed list, and works are protected by copyright only if they belong to the list. So literary, artistic, dramatic, musical work, broadcasting, typographical arrangement, sound recording, and it's like the seven dwarf, I always forget one, but I mean, there is a list of protectable subject matter, he has to belong to the list, otherwise it's not protected. For decades it's been considered not to be in line with European the EU copyright system. Now we have to see what's going to happen in the following years. But this means that if something that has been copied from your video game is not something that is on the list, is not clearly an artistic work, is clearly not the music, then you wouldn't have a successful case against a potential cloner or your video game. In the US, and the US is always amazing because there are thousands of cases in the US. They go to court quite often, and there is an extensive case law that's come from the US. This is just an excerpt from a case involving Tetris. I'll show you some picture later on. They simplified it into what is called the dual layer theory. You protect the software and you protect the audiovisual element. They're both protected. Full stop. Very simple, very straightforward. EU, we don't like things that are simple and straightforward, generally. So that's something that culturally, we don't approach. You can guess from my accent, I come from a European country. And we actually had to ask the Court of Justice. I mean, since we have technological protection measure in 3 different directives, the question was, so yeah, we do have 3 ways of protecting TPM. Which one of the directive which directive should we use when it comes to video game? And that is the case in Nintendo. And the court, to simplify to the most, said that video games are complex product. Video games are complex work. And this was an amazing finding. There was another decision pending Grund that then was never decided with a more specific question. However, what this being a complex work means is not fully explored. And I like to make a claim that on the other side, the Court of Justice was really clear in telling us that in order to be protected by copyright, you just need a work that is original and is expressed in a manner that can be identified with precision. So my claim would be, it's not a complex work. A video is a work. Is a work protected by copyright, full stop. And, but the consequences are virtually unexplored, and it does have a relevance how you define it. If you look at it as if you consider it as a film, there are substantially different rules that if you consider it a piece of software. And these rules change the way we look at authorship, at the term of protection, at digital distribution, and so forwards. Some of the questions we had them answered already by mistake. I mean, they were not what we was asked to the Court of Justice. The Court of Justice answered them anyway. And this led to what is the most probably fundamental aspect of a video game, the gameplay, the mechanics. And this goes back, when you look at it from a copyright perspective, to fundamental questions on originality and idea expression dichotomy. There are two of the biggest concepts in copyright law. And I'm not going to go through all the video. I have a lot of video. I want to keep it in the presentation so you can watch them later. But for instance, this is a video game that predates Angry Bird and has a very similar mechanics, but I'll skip it. I'm just going to talk over this one. Thank God there is no audio, because I don't know if you remember Pac-Man. The soundtrack might be daunting after a couple of decades. This is a very old case, and since I'm recorded, I decided to comment only on very old cases, so not to offend anyone of the judges deciding the more recent cases. This is one of the early cloning cases from the 80s, Pac-Man and MC Münking. I think the right way to pronounce it is. Pac-Man is the one on the right, MC Münking is the one on the left. Is this a clone? Yes, of course it's a clone. Is this a copyright infringement? It's not so straightforward. Because of course, if you focus on the gameplay and on the mechanics, I don't have to describe Pac-Man here, I'm so happy. They are the same gameplay and mechanics. But then when you start looking at the expressive original elements, you start noticing that most of them are not entirely copied, or probably are not protected. So the court has to go through a very careful analysis to determine whether or not any protectable element had been copied. At the center of this case, of course, Pac-Man is protected. Pac-Man was protected by copyright, Pac-Man was taken, and a lot of other aspects of the video game that are not immediately visible when you look, because of course you focus on the gameplay, you focus on the maze. Those were not the part that were causing the infringement. But Pac-Man, even if it's, you know, a margarita pizza missing a slide, that's where Pac-Man is coming from, is one of the long-lasting form of IP license. I think they had a renewal on a 40 years license that for IP in a video game is pretty rare to have this kind of license. Pac-Man is going to be with us for generations to come. And most of the time, judges, they are not playing the video game to understand this nuisance. They're just exposed to screenshot, or they're just exposed to, you know, what the lawyer is describing. This is the case from which I took the definition a couple of slides ago. Another interesting cloning case in the US. And when this borderline scenarios gets into court, they have a tendency, and this is my very personal opinion, to kind of create precedent, because, I mean, of course, cases based on the fact of the case, and then as lawyers first, and then academics, we are probably the worst in that. We try to extrapolate some very general concept that we want to apply to everything. This is a case that creates a bit of debate on the funding of the case, and I include the video so you can better figure out what I'm trying to express in this limited time. And this is another very important case, and then was sold by acquisition of one of the two companies. They created a lot of very interesting question for copyright, on subject matter of copyright, because when we start stretching what we consider to be protective, and when we start stretching what we consider to be similar and an infringement, then you create a little bit of a revolution in how we look at copyright protection in any of their countries. I use these 2012 cases because arguably these cases would not be successful in European countries, and definitely would not be successful in the way they were presented in the UK. So imagine when you're trying to explain a developer, or even sometimes I mean, people at the end of the decision-making process of a studio, this complexity when the case is not there yet. Trying to explain, I mean, what is the right amount of, because copying and pasting is generally bad, and I'm simplifying it. It could be not a copyright infringement, but it's not the right approach. But when it comes to inspiration, when it comes to use things that are just common in the industry, it's much more difficult to navigate this complex copyright question. The copyright is complex for a reason. It's there to protect the most sacred creation of the human mind. You don't want to make it white and black. There has to be some gray areas. This is again the video, so you would understand. And this, for instance, is if I can ask the technician to jump 10 seconds after we just see, this is probably a case you're familiar with. It's a couple of years ago during the pandemic in France. This is video game A, and if we can just jump now 10 minutes. You see video game B. It's really difficult to determine what has been taken and what was taken was protected or not. That for me, this case, for instance, is one of the key ones that highlights how we need to rethink the approach. Because of course, I mean, the case was successful under unfair competition law, but in the copyright part of the analysis, we see how probably, I'm going to make it personal so I don't offend anyone, and academics working in the field in copyright and video games might have a different understanding on what assimilation in an hyper-casual game is than a general court judge. And I leave it there. It is a matter, again, of awareness, but it's also a matter of education. I mean, this is not niche anymore. In the 80s, could have been considered niche to understand the relationship between copyright and video game. Now, it's definitely not niche anymore. Again, we jumping topic because I realize I'm running out of time. Even on basic concept of exhaustion, in which whoever you ask, there is no concept of digital exhaustion in Europe. There is actually a case won in France on the possibility to resell second-hand digital game. The course is going to be appealed. At the moment, there's been no changes in the wording of the license on Valve. But when it gets to video game, even something simple like selling and distributing the game might create unprecedented copyright question. Accounts transfer and selling. Before video games wasn't a thing. Key selling, try to explain key selling, the issue of buying the box game or getting the key somewhere else and reselling at a lower price. This is extremely damaging to indies. And it is an issue with the digital distribution, and it's something that copyright never had to deal with. Probably there is only one case in Germany. And of course, you cannot decide, a global approach. But copyright is not the only one, and it's not only complex when it gets to protect the video games. IP in general is also, you have to be familiar and ready to deal with it, because video games tend also to use a lot of third parties' IP in their creation. And in this area, limitation exceptions are very loosely harmonized. I mean, they are not harmonized. So some activity using third-party IP in your video game in some country could be totally fine. In the US, there is, again, extremely extensive case law to determine where it is for use. And sometimes when you're using an object that is from I don't want to call it the real world, but it's the outside world, the physical world, into a video. It's not only about copyright, it's about trademark, it's about design. And all of these form of IP, they have different regime for limitation exceptions. So something to be taken into consideration. General question I asked, do you have to clear the Eiffel Tower if you include the Eiffel Tower in your video game? And a lot of people say, hey, come on, it's so old, it's out of copyright. There is a lighting display that is protected in France, it's not protected in the UK, but they're all things that you have to consider. Of course, it's not the developer themselves that have to do it, but I think it's very important that they are aware that there are these questions to be asked, and they contact someone that knows and can help with this clearance. And this, even before the metaverse, this joint partnership between brands, between cultural heritage institutions and celebrities, now they are part of the video game industry. They are actually integrated in video games. Very quick list, I'm not going to go through that. We have a lot of questions still open when it comes to interactivity, because video games are not static, so you don't just protect the video game as you protect a film, and then the film is the same forever. Video games have to be played, there is an ongoing relationship with the player, there are players playing the video game in an extremely creative way. They may raise IP question connected to their creativity within the video game. And I don't even want to get into let's play streaming and esports. This is the big question. This is not a copyright problem. Sorry, it's not a video game problem. We had the user-generated content problem for at least 25 years now. We honestly have no clue how to solve it. We will see. There are at least 15 different academics that suggest a different solution. So far, however, the video game industry has been the best one in dealing with it contractually and actually allow, to some extent, within some margins, the use of their works in a creative way, at least with some limit, but to make it easier for their community to use their work for creative. There is much more I can go over for weeks. Copyright is not only the way to protect video games. Patent, that is generally considered a stronger form of IP, is also very crucial to video games. Not only for the hardware, not only for the software that can be protected by a patent, but also for the increased presence of patents focusing on the game mechanics, what I like to call the pure video game patents. It's very technical, but if you feel you are inventing something, you're doing something new, you are creating a technical solution to a problem, just contact a patent attorney. It is surprising how most of the time you show a patent claim to a developer and they tell you, but it's obvious, I mean, I've been doing it for 5 years. And then they try to describe something they're doing and you realize, okay, this is actually qualifies for a patent. And patent, we will discuss it this afternoon probably with Mike, they're really, they're an amazing tool, even if you don't enforce them. I mean, it's one of the strongest registered rights, can give you a lot of homogeneity. And most of the time, even if the video game is not successful, the fact that you have a patent for 20 years can give you a very strong position. But of course, patents are expensive. Patents are actually mainly misunderstood, of being extremely expensive, to be used. You always are afraid of someone suing you for a patent infringement instead of thinking, am I doing something that is inventive? Should I register a patent? And we get a lot of information from sources that are based in the US, where the regime is very different than under the EU IPO. And again, basically, they are misunderstood, fundamentally misunderstood, and the news they don't help. Probably everyone is aware of the Nemesis patent that took like 8 years to be registered in the US on a particular way to interact, or for instance, the medium split screen patent. They are reported by the news as patents that will create monopoly for 20 years, so no one can use it anymore. It's not real. Patent protects only what is specified in the claim. So you cannot just base your perception of patent on this news information. It's very technical, of course. I mean, I cannot get into the details right now, and always, if you think you're getting an invention, I mean, contact a patent authority. That's a very good approach. And most of the time, they will give you an advice for free at the beginning. I mean, there are a lot of. It is a good investment to have a relationship with a company that's making invention even beyond patent. And a lot of universities have clinics, and they can help. I'll skip that and moving to trademark. This is probably the easier, more straightforward way to protect multiple aspects of your video games. it comes down again to how much money you want to invest. Of course, there are obvious things that any developer should immediately register a trademark as soon as they start having a more public face. They can be used very well against game cloning. It's pretty straightforward to register, especially if you're using it. I mean, there have been difficulties with kind of fake registration or registration in bad faith. You register something just because you want to avoid other people to do it instead of you using the trademark. But they work really well. And now recently with Multimedia Mark, and again, if you're going to watch this video later, is gruesome. I mean, if someone gets shot in the head. This is a trademark application at the EU Trademark Office. Not gonna trademark not gonna be granted, but it's one of the first example that shows that you can actually use the audiovisual element of your video game as a trademark. This is very distinctive, and this is what I want to use to have your video games recognized. And again, as for copyright, it's a double-edged sword, because there is an increasing market to register what are being called fictional trademarks, right? They don't really exist yet in the real market, but become very famous and very distinctive in your form of art. Soon I'm going to remove Duff Beer, because I do believe that Arasaka is becoming probably more famous globally than the Duff Beer from The Simpsons. And this creates a lot of theoretical question on trademark, but is again something in which we can anticipate, registration of trademark in the metaverse, and I managed to use it twice. And while in the US we do have case law again, and it's pretty clear, in the rest of the world we do have only decision we can use by analogy on what we mean with trademark use, what do we mean with unconventional use, and definitely we need a little bit more clarification on, especially for using trademark within a video game. This is a case that would have answered a lot of questions, but unfortunately for me, not for the party of the case, it got settled. That involved the use of the Manchester United crest by using a mod in Football Manager by Sega. Very interesting and complex case. We will know yet. But this is a slide that I want to share with WIPO. We did a study on IP management of cyberpunk, and when you think of trademarks in video games, on one side you can register most of the aspects of your video game. Actually, the key aspect of the audiovisual part of your video game do register as a trademark. I don't know, the goal in Minecraft, that's a registered trademark. It's so much easier to stop, unauthorized merchandising on that claim instead of going for copyright. But on the other side, when you recreate an entire environment like in Cyberpunk 2077, you actually have to go and check and try to clear as many of those billboards as possible, because you might be infringing a trademark somewhere. This is expensive. It's time consuming, and apologies, again, my opinion, this is insane. It's not that it's because there is the billboard of a restaurant in country X, you're actually infringing their trademark. But these are problems that might actually even stop the distribution of your video game at some point if you don't clear the IP. The risk of getting an injunction for something you didn't even notice, it is an high risk, so it's something that we should look as the legal community. What can we do to make it easier? Because while of course there is full respect for third parties IP owner, there is also sometimes it's undoable, impossible to do. And if they were all protected by trademarks, probably project could have never make Cyberpunk, because clearing 5 or 6 of those billboards would be so expensive to actually destroy the entire project. And I'm using Cyberpunk because they wouldn't get a problem with that. But think about, sport game, car racing game. You need to get the license, and sometimes projects disappear because you start summing up the cost of using that form of IP. And this is again another example of trademark used by Cyberpunk. The last one is design. Design is another extremely important tools. Video game companies started registering a lot of design lately. I cannot tell you much about it because I know how important and easy to enforce could be, but it's virtually unexplored. I couldn't find a single case in which someone told us. I mean, design registration, there is no check. So you just apply for the registration. If there is no issue with administrative issue, the design will be granted. So I cannot tell you how powerful they are, but of course, I think they could be, they're cheaper than trademark. They are probably, in some aspect, even more to the point for what you want to protect in video games. These are just the honorable mention. I'll skip towards the end because most of the issues discussed are multi-jurisdictional, and I think we're going to have the question later.
Thanks, Gaetano. A very quick thing just to say that there's before the event, I sent to speakers a presentation from a few years ago during one of the GDCs, where there was a speaker, a lawyer, explaining intellectual property to game developers. And one of the first things he started is by saying that we have time for a game of PUBG, but in reality, in order to understand intellectual property, we need the time to finish The Witcher a few times, level up 70 levels in World of Warcraft, and so on. So it's actually really great, Gaetano, that you might manage to fit into those 30 minutes as much as we can on intellectual property. We'll have a series of questions later on. If I can, in that case, kindly ask Goran to join us on the floor and to have his presentation.
Hello, everybody from my side as well, and thank you very much for the opportunity, for the invitation. Very happy to be here with you today, and thank you, Gaetano, for the excellent presentation. You covered all the basics, so I'm going to concentrate in these next 15 minutes or so to maybe going into a bit more details about the Serbian law specifics, the Serbian IP environment, some of the items that developers should maybe take into consideration when developing their games in Serbia. So essentially, there are usually a couple of key questions that developers in Serbia should consider when they develop their game or when they develop their companies, the gaming companies in general. The so-called 4 Ws, starting obviously with what? What is it that developers should know, and what is it that they should do with their IP in Serbia? It comes down to a simple general answer that they should simply secure that the company fully owns their IP, and they should ensure that they don't infringe any third-party right. But it's simple enough, but quite difficult to achieve in practice. To do it, you will need to know at least some basic information about what IP is, why it is important for you, and especially in Serbia, how the Serbian law specifics interplay with the global IP concept that Gaetano was just discussing. So in essence, why is this that important? As some of the speakers before me told you, it's really the essence of your business. It's the legal stuff that protects not just the game you're developing, but also your business in general. It's what enables you to have exclusivity, and that's extremely important. That what enables you to utilize the creations of your intellect, to be the only one that can do it, and to be able to prevent anyone else from copying your creations without your authorization, at least. As such, this has a direct and profound impact on whether you will succeed or fail with your business. This is also something that typically the decision you're going to make today or when you start developing your game is something that may decide really whether you go bust or if you have a chance to succeed, assuming, of course, you do everything else the right way. And if these two reasons are not enough, the third one is usually something that our clients, at least, pay much attention to. Investors will definitely look into your IP in detail. And if they're going to do it, and if you are hoping to gain some financing, some investments, to make a great exit that you heard so much about from other companies, you need to take care about it now. And trust me, we know this firsthand. We work for a lot of foreign companies acquiring local gaming studios, and the level of scrutiny that they apply when they perform due diligence of a local company is mind-boggling, really. It's unbelievable, perhaps in some occasions for some gaming giants. It's something that sometimes puzzles us as well, and we have pretty much experience with this. Oftentimes, the IP deficiencies that we detect together with the colleagues we work for have a direct impact on the price that you achieve. Sometimes it results in, for example, a larger portion of the price being put into escrow account to secure for any losses that may occur for the purchaser in case the deficiencies are more serious. And sometimes even we've had a couple of cases that the deals did not materialize. They failed to complete because the noted deficiencies were of such gravity and the resulting risks were so high that the purchaser decided not to proceed. So it's really essential. The investors are heavily relying on analyzing your IP and trying to search if everything is fine, and since they are doing that, you should be doing that as well. And when it comes to the question, when should I take all this into account, when should I do what I need to do with my IP, well, the answer is obviously pretty straightforward. The sooner the better. We obviously understand and we see in practice, especially working with SGA and the startups, the money is tight at the beginning. You have to pay a lot of things, the developers, the equipment, the electricity, the space, everything. So you don't really want to, let's say, waste money on the legal stuff, but you can't wait too long. Really, if you wait too long, if you don't do the right moves at the right time, you will maybe learn the hard way, the awful truth that what can be done fairly easily at the beginning becomes much, much harder at later point of time to correct, to remove the obstacle for investment. So we would advise to consider doing this at least at the incorporation time or soon afterwards, and to have this in mind regularly whenever you are investing into new projects, starting a new project, or expanding maybe your existing product line. And finally, when we think about which IP right is the right for me, Gaetano went into details about what IP rights exist. In Serbia, it really comes down most of the time to copyright and trademark. It's the two rights that protect the game you develop and the brands under which you market that game. So pretty much copyright and trademark. Patents theoretically, yes, for certain elements of the game, but it's in Serbia, it's still in early stages, and we won't be wasting too much time on that. And Gaetano already mentioned a couple of key aspects, so I think we can move on to copyright, which under Serbian law obviously protects works of authorship, and as we expand on that, works of authorship in Serbia, it's pretty much any author's intellectual creation which is expressed in a certain form. So from the gaming perspective, it means the gaming, the code, the software code that's written for the game, but also the artwork, the characters, maybe the storyline, even if it fits the above definition. What's not covered, and this should be taken into account, we see oftentimes that startups ask us this question: can I really cover the idea, the gaming rules, the concept in general? This is not copyrightable, although we see some maybe change developments in the US, and Gaetano showed a couple of examples In Serbia, this is still interpreted pretty restrictively, so ideas are in general not copyrightable. Although, on the other hand, we don't see really many gaming litigation in Serbia, so we'll maybe have to see how the courts take this position. Who owns what in Serbia? One of the specifics, especially comparing to the common law systems, is that in Serbia, author is always an individual, a natural person. So at least initially, the copyright on a work of authorship belongs to the author or to a legal natural person that acquires certain rights from the author. Those rights can be, well, we have the dichotomy that exists elsewhere as well. Economic rights, meaning the rights to commercial exploitation of the work, and on the other hand, moral rights. Economic rights you can assign or transfer, moral rights you cannot. They are tied to the author and they are stuck with him. And one of the key concepts for copyright is, unlike patents and trademarks, for which you need to file an application with the IP office and to get a certificate of the decision granting the patent or trademark. In copyright, we don't have that. It's fairly simple. Copyright is automatically given, protected, meaning the work is protected at the moment of its creation, and there is nothing that you really need to do to achieve that. You simply own it as soon as it's made. You own it worldwide. You can file an infringement claim anywhere in the world against anyone who infringes it. There is, however, an option, I think we'll be hearing about it after as well, to deposit a copy of your work with the Serbian IP office. It's a useful tool. It does not grant you the right, it does not affect the creation of right, but it secures evidence. It secures evidence that at one point of time you were in the possession of the code, and it creates a legal presumption that the person named as the copyright holder in the application is indeed the copyright holder, and anyone claiming differently would need to prove it. It's also important for using certain tax incentives in Serbia, the so-called IP box that's really popular and hot these days. So in order to use the IP box, you would need to deposit the copy of your work with the IP office. And now moving along to transferring IP, and knowing that an author is always the one that originally owns the copyright. What needs to be done in Serbia, elsewhere as well, but in Serbia specifically, due to rather specific rules, is to ensure that the IP ownership line is interrupted, going from those individual authors to contracting companies, all the way to your company and downstream to your end users. So what you need to ensure is to have proper written agreements covering the assignment and the transfer of copyright to your company in order to have the full IP. And in Serbia, this is maybe where the Serbian law specifics come best into play. We have three usual relations that Serbian developer companies have in this respect: a relation with their founders, shareholders, their employees, and external contractors. And each of these has certain specifics we're going to maybe quickly jump into. When it comes to the founders, we typically tend to remember those photos, I don't know, Bill Gates or someone else from the US tech companies working from some kind of a garage. In Serbia, it's not really that much different. Even now, people tend to start from their room in the parents' apartment or from a dorm or from some office, but what we usually see in diligence procedures that we perform when a foreign investor acquires a local gaming studio is that there's a certain time period, like 6 months or a year, 2 years even, between the time that the founders of the company, imagine two guys working on a game code, started to develop the idea, started to develop the code, they somehow get to a point where it gets more serious, and then they incorporate the company. And what we typically see is, in the majority of cases, that IP that's been created prior to the incorporation is not transferred to the company. And when the investors analyze this, they see that it's not in. And it's fairly simple to correct if the same guys that started working on the code are now selling the company, but oftentimes a few founders, few shareholders exit the company, new ones come in. Then when you realize this and the investor is already at your door, you need to think, am I going to chase these two guys that exited the company that developed the IP at the beginning? Will they ask for money now that the game is a big hit? What if they exited really on not the greatest of terms? We had a fight, etc. So it creates very, very serious issues that investors don't like to see, and it really affects either the price or the decision to proceed with this. So our advice is always to consider contributing this initial IP to the company's share capital as a so-called in-kind contribution. And when you do this, there's another issue to take into account. Well, under Serbian companies law, when you contribute an in-kind contribution, such as IP, to your company's share capital, you need to determine the value of that IP. And you can do it in two ways. You can either agree, between all the shareholders agree that this IP that you are contributing is worth, I don't know, €1 million, or you can hire an external evaluator, certified evaluator that's assigned to do that. And typically, younger startups do that by way of an agreement between the shareholders. It's easier, it's quicker, cheaper. But in case you do that, and in case your company later is unable to settle its obligations, the Serbian law allows the creditors of the company, meaning any supplier, to challenge this shareholder's evaluation before the court. And if the court determines that you really inflated the value, you said it's worth $1 million, actually it's worth 50,000, the shareholder that contributed that IP would be ordered to pay the price difference to the company. And this is enforceable. You can lose your house, your car. This is really something that the startups and their founders that we often advise don't know at the beginning, and this kind of think, let's inflate it a little bit. The investors will be pleased to see that we have $1 million IP already in the company, but it's a trap, really. You should always hire an external evaluator, or maybe go more realistic with your estimates. The second, key relations with your employees, really, this is something that troubles me as, well, you have certain default rules in Serbian corporate law saying that this is the position of the law and you can derogate from it by way of an agreement, employment agreement. And it's rather favorable for the software developers, gaming developers as well. It pretty much says that in case an employee develops software in a company, the permanent owner of the copyright, the economic rights obviously, is the company. And in case it's non-software IP, artwork, etc., not in a game, but for example, merchandise or posters, etc., then this employer's ownership is limited to 5 years initially, when the copyright reverts to the employee. So essentially, what you should do is you should carefully draft these IP provisions in the employment agreement to ensure that you own full, uninterrupted IP on both software and non-software works. But what we see in practice is that in at least a third of the diligence procedures we see significant issues. We often see that larger companies, more successful ones, the ones for which we assumed had proper legal representation, have agreements, employment agreements that derogate the default position to the benefit of the employee rather than the company. So it's really something to take into account and not to be taken lightly. This also applies for engaging external contractors as well, and the default position is maybe even less great than for employees. You should carefully evaluate the language, as some economic rights needs to be explicitly designated to be transferred. There are some licenses for further assignment to be given. There is some issues with some special remuneration as well. So do give your proper attention to this, as it may have serious consequences. And with respect to copyright, what do we see in practice? What are the most common issues that we encounter? I would say, when I was thinking about it up front, it's usually the quite liberal use of US or UK template documents. They simply transfer it to Serbian company, they don't even translate it. they don't adjust them to Serbian law specifics. They simply, for example, we oftentimes see the so-called PIA, the Proprietary Information and Invention Assignment Agreement. That's the document that US companies love. They establish a local subsidiary in Serbia, the development center, obviously, and they give the employees of the local company their documents to sign and to say that they assign all copyright to the US shareholder, not the local company. And at the same time, in parallel, those same employees have employment agreements with the local company saying that the local company is the copyright holder. So when it comes to doing the diligence on that company, you struggle a bit to see where the IP is, really. And it's not really an issue when the investor is purchasing the entire group, but if they're purchasing under the local company, what do you do then? It's really mind-boggling sometimes. What we often see in that context when we have a shareholder in the local development center is that the company somehow neglect that there is a special IP transfer tax. Whenever you transfer IP to a foreign company, there is no VAT involved, and then the IP transfer tax comes into play. It's 2.5% that somehow is not reported in practice. It's never paid. So there's a tax liability connected with those kind of arrangements that should be really noted. And finally, one of the things that we tend to see, because maybe of the US templates, is the quite a liberal use of unilateral declarations. They give to employees or to individuals in Serbia unilateral declarations saying that they assign all the rights to the foreign company and that they take some additional obligations as well, to keep confidentiality, etc. It's the language I hereby assign, and will always assign everything that comes in the meantime, and will keep confidential. We'll do everything, and he signs it. That it's not an agreement; it's a unilateral declaration. And in Serbian law, it's, well, to say at least, it's quite problematic. It's very questionable, if at all, if this could really be a source of obligation, because in Serbian law, unilateral declarations can be source of obligation only when it's prescribed in the law that they are. And for IP transfers, this is definitely not the case. We often see quite liberal use of open source licenses by Serbian developers. It's an industry standard, everybody is doing it. It's relatively easy to do, it's sometimes encouraged in the environment, and that's all perfect and fine. But oftentimes we see that local developers use a specific type of open source software, the type that's licensed under the so-called copyleft or restrictive licenses. And they don't tend to, as Gaetano said, they don't tend to read the fine print. Those types of licenses give you the right to go to GitHub and get someone's source code and to modify it, to incorporate it into your own product, to distribute it, to commercialize, to earn money from it. But this is given under a specific condition that you must also license your entire product under the same license terms, meaning that you must make it freely available to everyone. You must disclose and publish your source code, the modified source code for anyone to use, and it kills exclusivity. So we would also advise checking in advance what parts of your software you're relying on open source licenses and what licenses are you relying on. And what we often see when it comes to closing the deal, when we detected some of these issues, the investors tend to either chase employees or founders to get some confirmatory assignments, but it's difficult when certain employees or investors are no longer with the firm. We see issues with these open source licenses that the investors tend to scan your entire source code. They put it in a piece of special software. We're seeing like Black Duck or something like that. And that software scans your entire source code and identifies what part of your source code is based on open source licenses that are maybe restrictive. Then they have to think how much money would it cost to replace those parts. So it's really something that affects everything at the end. And let's quickly go through the trademarks. I'm saying quickly because the Serbian trademark environment in general is pretty much modeled on the EU standards. No no specific issues with this. I think the issues we encounter are pretty much the same as anyone encounters in the EU, at least. What is unlike copyright, trademarks require formal registration before the IP office on a first come, first served principle, or in Serbian, ko predevici njemu devojka, so you have a priority if you apply first. And what's important is that the trademarks are protected on a territorial principle, meaning you apply in Serbia, you get a trademark in Serbia. It does not give you exclusivity in the EU or in the US. But there's an international mechanism to ensure that as well. And this is where WIPO especially comes into play. So you have an option to file an application in Serbia, and then you are granted 6 months sort of grace period, 6 months priority, where you can check if your product is going well, if it's getting traction, and then you decide to invest additional money into protecting it elsewhere, especially EU or US as your main export territories. So this is good because you have 6 months to decide and to file an application, for example, in the US. If you do it, you will have priority over any trademark application filed there in the meantime. So it's really something that we advise our clients to take into account. And we had great examples when the clients really complied with this. We had an excellent gaming company, local gaming company that used to, well, these were smart guys. They accepted our proposal to put a foot in the doorway to simply apply for a local trademark, and then they had 6 months to extend it to other territories. It was really a battle. They were tight with the money. They were not really happy. They said, we have a patent, why do we need another one? So it took some persuasion, but then they decided to do it. And about a month afterwards, they got a letter from Facebook. It was a gaming platform of choice at the day, and Facebook was notifying them that their game is going to be taken down because they received a trademark infringement complaint. Someone, I think from Vietnam or somewhere, someone registered, applied for a patent with substantially the same name as the product after they launched it. And they filed this to Facebook, hopefully for some settlement, or I don't know what. These guys were in panic. We received an urgent email saying that what should we do now? And hopefully they decided to go international. They had a grace period. They applied earlier. They had priority. This was reported to Facebook. Evidence was shown. They were reinstated the same day, and the game went on to become a big hit. But why I'm saying this, it's the details, it's the choices really that you make today that can decide whether you succeed or fail. You can do everything else the right way. If you fail this at the beginning, you may risk the failing everything. So this is something to be taken into account. In terms of what investors check, they check the regular stuff. Do you have all the IP covering your brand name, your company name, your key products? Are there any disputes? Is there anything else they should worry about? Is there some kind of an intra-group license? If your shareholder holds the trademark and gives the local company a license, and only the local company is being the target company being purchased, then you need to reevaluate your agreements in order to keep the right to use a certain specific trademark. So the bottom line with this is take good care upfront, be proactive, and we know money is tight at the beginning, but some money you need really to invest to keep your chances open. If not, everything may be crumbling down overnight, and you don't want to do it in case you invest so much money, so much time, so much effort into developing your video game. And you should explore the options, really. As GA has, if you're a member, they have a program allowing for some free consultations. You need to at least learn the basics and then see if that's important for your case and whether to invest. So ask someone. You have friends, lawyers. If you don't have money, you have SGA, you have these presentations. It's really important stuff. So that's it from me at this point. I'm going to thank you for your attention and hand you over to Ryszard for further.
Thanks, Goran. still, if you can just join us up here, because we might have a quick question, and we're running late on time, as always, it always happens. But in that case, if I can kindly ask Zorica to join us and give us a presentation on the we don't have any time, but for 10 minutes, 10 minutes, absolutely. If you could go ahead, that would be great. Of course, it's important information for us. Go ahead. Thank you.
Thank you. Dobar dan, poštovanje. Ja sam Zorica Gulas, šef odseka u Zavodu, šef odseka za autorsko i srodno pravo u Zavodu za intelektualnu svojinu. Danas bih htjela da vas informišem o tome koje su to usluge koje Zavod za intelektualnu svojinu pruža, koje vama koji se bavite stvaranjem video igara mogu da budu od koristi. S obzirom da imam 10 minuta, krenula bi odmah sa uslugom koju pružamo već više od 20 godina, to je usluga deponovanja autorskih dela, odnosno ukoliko za tim postoji interes, autori ili nosioci autorskih prava mogu da se obrate Zavodu za intelektualnu svojinu, da svoj primerak dela deponuju u Zavodu. Zavod na osnovu tog zahteva dužan je da primerak dela prihvati, da trajno čuva, dakle zauvek čuvamo primerak dela i o tome autorima, odnosno nosiocima prava izdajemo potvrdu. To je u stvari i cilj zbog čega nam se autori obraćaju, a to je da bi pribavili potvrdu. Tu potvrdu koju mi izdajemo jeste, s obzirom da izdaje organ državne uprave, ima snagu javne isprave. Stoga ta potvrda autorima koji to žele i ukoliko za tim postoji potreba služi kao dokazno sredstvo. Kao dokazno sredstvo, dakle, autori ne moraju da se registruju, ne moraju da deponuju, ali to je jedna usluga koju mi pružamo i shvatili smo kroz više od 2 decenije da i dalje postoji veliko interesovanje autora, s obzirom da u određenim trenucima autorima je neophodno da, bilo zbog toga što se prijavljuju na određene konkurse, bilo zbog toga što je to jedan od uslova, recimo, javnih nabavki ili zbog toga što im je potrebno za potrebe dokazivanja pred sudom, neophodno je da pribave jedan ili više dokaza o tome ko je autor, šta je predmet zaštite, kada je autorsko delo nastalo. To je upravo, te informacije se nalaze u toj potvrdi koje Zavod izdaje. Dakle, potvrda ima snagu javne isprave, to znači da sve informacije koje se nalaze, svi podaci koji se nalaze u potvrdi smatraju se kao istinitim dok se suprotno ne dokaže. Mesto gde se to dokazuje je sud i iz iskustva i kontakta sa našim korisnicima to se pokazalo kao značajna usluga koju Zavod pruža i za koje postoji interesovanje iz godine u godinu. Čini mi se da u poslednjih par godina od 2019. ili 2020. donet je set propisa koji zapravo omogućavaju nosiocima autorskih prava i podnosiocima prijave patenta ili nosiocima patenta i određena umanjenja takse kada je reč o porezu zapravo na dobit pravnih lica i primetili smo da upravo i zbog tih propisa došlo je do povećanja broja deponovanih autorskih dela. To je jedna od usluga koju, znači, pružamo već više od 20 godina i postoji za tim interesovanje. Procedura je krajnje jednostavna, za podnošenje zahteva nije vam potreban advokat, možete vrlo jednostavno i u roku od par minuta da popunite zahtev i da predate taj zahtev u Zavodu, a sam postupak od podnošenja zahteva do izdavanja potvrde traje kratko, maksimalno traje 30 dana od dana podnošenja uredne prijave. Praktično to se dešava mnogo brže, znači u periodu nekih od 7 do 15 dana i to je takođe jedan kvalitet koji naši korisnici prepoznaju, da mogu brzo i jednostavno da dođu do tog dokaza. Sve informacije, odnosno sam primerak dela koji nam se deponuje nije dostupan javnosti, možemo ga predočiti na uvid samo podnosiocu zahteva ili eventualno sudu ili drugom državnom organu napisani zahtev ukoliko se vodi dokazni postupak, a informacije o tome koji su to, ko je podnosilac prijave, ko je autor, koji je naziv dela, mi o tome vodimo javnu evidenciju i to kroz knjigu evidencije, ali i već nekoliko godina kroz javnu bazu koja je takođe dostupna na sajtu Zavoda. Za neka druga prava intelektualne svojine za koje smo evo sad od početka pa na ovomu ponavlja se i to jeste tako da zapravo kod video igre sva prava intelektualne svojine su nekako protkana kroz video igru. Za neka prava kao što su patent, kao što je žig, kao što je industrijski dizajn, bit će potrebe da se obratite Zavodu formalnim zahtevom, dakle za autorska prava možete i ne morate, deponovanje nije obavezno, ne utiče na zaštitu, a kada je reč o drugim pravima kao što je patent, kao što je žig, bit će neophodno da podnesete zahtev za priznanje prava i da pokrenete jedan upravni postupak pred Zavodom i da sačekate odluku u vezi sa tim da li ćete steći pravo na žig ili patent i tako dalje. Ono što mi se čini zanimljivo i vidim i iz razgovora sa kolegama ovde i sa prisutnima da pored autorskih prava svakako postoji jedan veliki prostor kada je reč o video igrama da se zaštiti žigom bar naziv igre, to je prosto prepoznatljivo i ima smisla podneti prijavu za priznanje žiga. To je, kažem, sve te postupke obavljaju se pred Zavodom za intelektualnu svojinu. Napomenula bi i to da mi već dugi niz godina na našem sajtu dostupno je za sve naše korisnike, možete pregledati sve registre, dakle baze podataka o prijavljenim i odobrenim žigovima, takođe i o patentima, dostupna je i ova baza evidencije deponovanih dela. Samostalno možete pretraživati sve te baze, to će vam omogućiti da donesete bolju odluku u vezi sa tim da li vas zanima zaštita nekim od prava industrijske svojine. Takođe već dugi niz godina, ja mislim od 2010. ili 2011. godine u okviru Zavoda imamo i edukativno-informativni centar. To je centar koji je sastavni deo Zavoda, kojem je glavna delatnost u stvari da informiše, da daje odgovore na pitanja iz svih oblasti prava intelektualne svojine. Organizujemo seminare, izlazimo u susreti na individualne zahteve i grupne u vezi sa pojedinim problemima koje se, ukoliko postoje u vezi sa zaštitom prava intelektualne svojine, kolege iz edukativno-informativnog centra nude i dijagnostiku prava intelektualne svojine i veoma smo mi uopšte kao kuća otvoreni i van svih ovih upravnih procedura koje vodimo, stojimo na raspolaganju i za sva pitanja koja stranke imaju i uopšte stvarno u najširem smislu građanstva, a koje se tiču prava intelektualne svojine. Ovo je prilika i da vas pozovem da posetite i sajt Zavoda, a ujedno i da ukoliko ima bilo kakvih pitanja i ja, ali i mnoge moje kolege, ne samo iz Odseka za autorska i srodna prava, već i iz Zavoda, bit ćemo prisutne danas ovde ceo dan sa vama, bit će pauze za kafu i bit će prilike da razgovaramo i da postavite pitanja. Nadam se da ćemo imati odgovore na vaše pitanje. Hvala vam.
Thank you, Zorica. Maybe still if you can join us for a moment here, and better than good timing, for sure. Thanks so much for this, and we're, again, running late, of course, as always, for the time, but let's just use a very quick opportunity to ask some questions. Before that, let me mention that I just realized in the document you showed, in the slide you showed, it's nice to realize that from one year to another, there's a jump of 33 video games being registered, which is actually an indication of how active this is becoming of an industry here in Serbia. before giving the floor, perhaps we would have one question from the floor and one question online. But if I can use that still, since I am the moderator, I will reuse that opportunity to ask that question. All right. So I'm this. So I decided to leave WIPO, which happens, and to pursue my dream to develop a video game, and I decided to move to Belgrade. I have a great programmer friend here in Belgrade, and I decided to lose all my knowledge about intellectual property. And if you can give me, as a new game developer, without any knowledge about IP, any business knowledge about video games, I just have this idea to develop an RPG, which I was always dreaming of, what would be in 2 minutes the advice you would provide to me? If I can start with you, Christina.
Well, first, definitely, maybe your first game shouldn't be an RPG.
Good point. Good point.
Other than that, when it comes to IP, definitely connect with the community. We have a Discord server dedicated to everyone employed in the industry. There you can contact directly teams that already went through all of these processes. So first-hand experience is crucial. Then through the SGA, as Goran mentioned, you can have some additional benefits and some things that can get you introduced to legal and tax teams and companies here in Serbia that can give you some help. And of course, there's the official institutions that deal with this, and as our speakers mentioned, they have an open desk or like an info desk for all of these things. So definitely connect with the community, use the SGA resources, and get acquainted with what the state is officially offering.
Thanks, and I'm taking note. You'll be surprised. Gaetano, the same question, and I have no knowledge about intellectual property anymore.
Well, you want me to do it in 2 minutes?
2 minutes.
No, the first thing is be aware that, for instance, I mean, depending where you want to move to create your video game, there might be already copyright implication. And so, I mean, Serbia sounds like a good choice. I mean, some of your rights will be protected better than in other more industry-oriented copyright jurisdiction. So that's something to be aware. And my suggestion is to be in touch with the local organization and with a law firm, especially because you cannot predict what your issue is going to be until you don't start working on the video game. For instance, I mean, if you want, you can immediately download in the game. For instance, depending what you want to do, if you want to do it by yourself, if you need to hire some local talents to help you with your game, you can skim through the book to the part that you're interested at the moment, and immediately decide whether or not you have to call someone with much more ad hoc experience to help you navigate it through, because it is the full awareness, the major issue. I mean, no developer will have to deal with, applying for a patent anywhere. I mean, this is not what is expected, but at least trying to understand at which point it's important to do something. You made an extremely good point. I mean, at the beginning, this is the crucial part, because if you're starting you start creating IP the moment you start thinking about your video games, and you do it with friends, and most of the time the actual problems will be down the line in 5 years, but there are problems that you create immediately. I mean, there are so many stories of two friends chatting about a video game and starting making drawing, and then they have a fight, or someone chooses another career and moves to security system for banks instead of the video games. And who came up with that character? Who made that first drawing? Who created that very cool mechanics that probably that was the inventive step for the patent we're applying for? And you don't have the paperwork, and you don't have the same friends. Those are the worst scenario that can happen. So be realistic, have a professional approach. I mean, making games is fun, but sometimes you have to spend time on the boring pit.
Thanks, Gaetano. Goran, and not to contact a lawyer.
it goes without saying.
Always copyright.
No, really, following up on Gaetano's introduction, it's really to do your homework. Read what you can read about it. It's not really the same time as it was like 20, 30 years ago. There's so many resources you can read from. You can go to SGA's website, to other industry leaders. There are so many information where you can gather key facts that you need to know to get started. You can visit these conferences. If you don't have the time, and I understand typically the CEOs don't have, you need to delegate. You need to assign someone the role to check if everything is legally, at least basically in order. You can cover all the aspects, but you need to cover the basics. And it's really available at this point. You just need a proactive approach early on. If you do that, you're halfway through.
Thank you. Zorica?
I can only agree with all of you, and maybe to engage Goran too.
Thank you. And then I'll give that opportunity to the room. If there's perhaps any questions here. Director Maric, please. Yeah. Yes, of course.
I'm sorry, I know that we are running out of time right now, and I'll try to make it very fast. First, I would like to thank to all the speakers for the really excellent presentations, very informative. And I have one very purely legal question for Mr. Gaetano. And first, I would like to make my impression that you touched probably all possible questions that I could imagine about the copyright protection on video games. But if we can back just for a few seconds on the Pac-Man case, because it seemed to me very important for the understanding what is actually the subject matter that has to be protected through the copyright law when we come to video games. And you also mentioned that, I mean, the whole point is what is actually the video game from the technical point of view. So I'm not a technical person without any technical background. As an average lawyer, my understanding, so average mind, average lawyer, it's nothing extraordinary, but my understanding is that the video game is purely computer program. So when we come to the computer program, it's the source code. At least in Serbia, we understand like that. So the set of the rules that is made up by the one who made the program, and those are the rules, the instructions that the software gives to the hardware. And that's what is protected when we come to the computer program, and that's probably the same thing. That's my first question, video games as well. And then you make a comparison between the Pac-Man and the clone video game, if I use the proper term, I'm not sure. And there was a dispute, was it actually the copy, legal copy or not? That's my understanding. But what is actually the question when we come to the video game, and not just the video game, but the games in general? Do we protect, through the concept of the originality, the rules of the game, like a chess, like, I don't know the English term for the, I don't know, Neljutice Čoveče or whoever can help me, but, you know, those are the rules that are purely original. But do we protect it as a video games? And that's another question. And my impression, when we come to the protection of the video game, what is protected? That's the source code. Design, like a characters, it also can be protected in Serbia, but not as a part of the game as such. It can be protected as a fine artwork, for example. But, I mean, we can discuss about it later on during the break or whatever. Thank you.
Okay, this is the toughest question possible on what is a video game from a copyright perspective. So, software is definitely a component, but it's not the only component. A video game is not only the 3D engine, it's everything that runs through that engine, and they're all protected. The thing is, different jurisdictions give different attention to a specific elements over others. And it will depend on the jurisdiction. And jurisdictions are taking very different approaches when they look at video games. Some jurisdictions, they consider them films, and they just cut the basic. At the end, the software is helping you playing the film. I totally disagree with this parallels, but some jurisdiction did. On the protectability of the essence of the video game, on the gameplay, the mechanics, that is a tricky one, because that's an idea. So as original as it could be, it's still an idea and it's not protected by copyright. However, and there is a big however, some mechanics are really creative, and they are creative ways to combine different mechanics. So a creative combination of ideas, and you always accuse me to sound too philosophical and theoretical. Original combination of ideas, depending on the jurisdiction, could qualify for copyright protection. So even if you're taking different mechanics and you're putting them together in a creative way, in some jurisdiction you might be entitled to copyright protection for that. The thing is, the fact that we don't all agree globally creates problems. So you have aspects of a video games that are protected in country A, but not in country B, and it's a global business. And then practitioners have to advise you on enforcement on a global scale. It's something that no one really wants to do. You can actually draw a line. I mean, the US is much more welcoming, creative contribution to combination of ideas in the protectability by copyright. On the other side of the spectrum, probably you have the UK, in which an idea is an idea, a combination of idea is a combination of idea, not protected by copyright, simplified to the most. It doesn't matter how original it is. And in the middle, you have a lot of countries that are actually following the two different pathways. With China, they become very interesting because there is case law pointing at both directions. So it's not simple to actually give a straight answer to this question. It would be fantastic if WIPO will actually invest in determining whether or not we can create a consensus, not changing copyright law, but create a consensus. It is a new subject matter, and I mean, some copyright laws, we have pantomime, expressly protected in some jurisdiction, word of engravings. Let's mention video games a little bit more. Sorry.
Thanks, Gaetano. Point taken. If I can, I see there was a question in the back. Perhaps we can get the microphone. Was it the case? It's answered already. Okay, good. In that case, we still have our online community, we can't forget, of course, and I saw that there were even 90 participants joining us. And Anastassia, can I turn to you and ask if there's perhaps a question from the online group participants?
Yes, thank you. So we have actually a question that just came in from, I guess, an aspiring young IP lawyer. So it is connected to this field. I will share my screen and will read out as well the question. So the question is as follows. Tips to young lawyers that want to be involved in the video games industry. What are the crucial parts or elements that a young aspiring lawyer should start with based on IP? I guess, what tips could you give to a young lawyer who is just starting out and is presented with a case or with questions by game developers? Thank you.
No, the thing is, it's really difficult. I mean, follow your passion, because I mean, if you want to become a video game lawyer, of course, I'm assuming you are passionate about video games. And it's not only IP. I mean, it's a little bit more complex when you deal in practice. I need you to help me on this question, because I mean, you have to have a strong IP background. You have to have something that no one can teach you. That is an understanding on how video games work and how the industry works. I mean, it's really difficult to read it if you don't experience it. And you have to understand the basic of data protection, content regulation, labor law. So it's much more beyond IP. If you want to start, there are a lot of materials online reading. There are a lot of universities that are organizing a seminar, most of them for the first time actually this year. And depending where you are, there is definitely a local community, a trade association, an industry organization that for you to join, not only remotely but also in person. I don't know where you're based. There is definitely something going on. I mean, 10 years ago we couldn't tell that, but now I can guarantee there is something going on. And the best way to approach the industry is to really get involved.
Goran.
Thanks. Well, I agree with pretty much with everything Gaetano said, but the passion part is really crucial. Unless you have at least a certain amount of passion for video games, you won't really realize all the potential that a young lawyer should have working in this environment. You have to be able to talk to developers. In order to talk to developers, you cannot really be that judge from Gaetano's screenshot that simply compares two screenshots. You need to know how the mechanics work. So you don't have to be an avid gamer, you don't have to play 10 hours a day, but you need to be present, you need to know how stuff works, you need to connect with people, you need to know what's happening. As a couple of presenters mentioned, this is a fast evolving industry. Things change year after year, so you have to keep up updating yourself, you have to play at least a bit, you have to talk to these people, and you have, if you're an individual lawyer, you can't really rely simply on IP. You need a bit of a wider picture. You can protect someone's trademark or advise on copyright issues, but if they fall big on GDPR, that's an issue. If they fall big on general corporate stuff, incorporation, contribution, that could mean a lot. If you fall down, if you have 100 employees and they all have the same issue with employment contracts, the damages could multiply 100 times. So either you have a team, but you have to have a basic understanding of these related law areas that come into play, just for you to be able to identify where the issues are. So you can maybe engage another specialist, but you can't be that specialized. And the tip to a young lawyer would always be, okay, go follow your passion, be a gaming lawyer. It's really an excellent prospect, but tend to go a bit further to gain wider experience and read everything you can get a grasp on.
Thanks, Goran. I know that we still have some questions potentially also online, but because we were running on that time and we need to fill up on coffee, we do a 10-minute break. And just before that, still I gotta ask Goran, your favorite game of all time?
Yeah, I'm a football lover, so it's EA Sports, FIFA, and Championship Manager. So many hours, so many broken joysticks and keyboards.
Thanks.
It's good.
And see you back in 10 minutes after the coffee break. Thanks.